Center studio is Henry Maina, who's the Deputy Director of Article 19. Thank you so much for joining us on News Center. So first, I'd like to hear your response or your reaction to this particular ruling.
Yeah, thanks so much, Betty, for having me. I think the first reaction that this is a big win for freedom of expression and media freedom in Kenya. It is also a call to the executive through the Attorney General to try and clean up the penal code of crimes that may not sit pretty with a new constitutional dispensation. So I think it's a big relief knowing that we have journalists who are still undergoing trial on criminal defamation charges. We know of Kurgat Marindani. We know of a few others who still have similar matters. And it is a relief that the High Court has seen it fit to place Kenya where it ought to be, a democratic state that, yes, protects the reputation of people, but it does not do that at the expense of the public, so that where individuals are defamed, it is their duty to go to court through a civil mechanism where they would seek damages, as opposed to using state machinery to incriminate, intimidate people who want to hold them to account.
How would you say the impact of these cases which have been there, really, like you mentioned, the bloggers, the media practitioners who are in court right now battling that criminality of using that space of social media and others. How can you describe the impact of this in the past few years, months?
One is to understand that the criminal charges have a chilling effect. So what it does is that it pushes you as a journalist to avoid cases where you are likely to face such charges. And whenever there is that chilling effect, because the issue of imprisonment hangs on you as a sword of Damocles, and the result is that you shun stories that are of public interest purely for your own survival. We also know that similar cases have come up where bloggers or citizen journalists or whistleblowers wanted to point out cases of impropriety, cases of public officials misgoverning, and yet to do so you required some surety of sorts that you will not be prosecuted. And if you're going to be prosecuted, then you know that the criminal charge hangs on you. Even sometimes when you win, you notice that those of us who want to get certificate of good conduct, you go to CID and they will tell you that you still have a pending criminal case. So then this hounds you for life, purely for an act of you being professional and just doing what a good journalist is required to do.
All right, but then, Henry, where do you really draw the line from giving, the bloggers and, the media practitioners space to, of course, practice or to write, freedom to express themselves, in an open space, from, them defaming or saying, things about other people? How do you draw the line from that?
I think the starting point is to understand that in this case, we did not say that Kenya ought not have defamation laws. All we were pointing out is that Kenya ought not retain criminal defamation laws, because Kenya has elaborate laws on civil defamation. We have a Defamation Act, which clearly provides for civil remedies so that we do away with the issue of retribution and sentences as in criminal charges, but focus on the issue that if you can prove that you are defamed, then pursue an individual interest through a civil court. Do not use state resources to intimidate journalists purely for protecting private interests.
All right. There was also a call to review other laws that sort of like curtail or affect the freedom of expression. Maybe you can just talk to us about which other laws are these?
Increasingly, the country retains a number of those laws. And apart from retaining provisions in our 1930 Penal Code. We have provisions that are a bit nebulous. Some of them are contempt of court laws that were recently passed. We also have undermining public authority provisions, which in reality do not mean much. It's just that if you wanted to hold a public official to account, must you seek their permission to do so? And if they deny you that permission, then you are likely to be charged with undermining public authority. So we've seen situations where a journalist wants to cover a certain incident, and police officers who may have been complicit in crime block the journalist. But when they do so, they also have this legal tool they can use against the journalist who just wanted to do their work. So we still have a litany of such provisions in our penal code. Ideally, there are 22 other provisions that are problematic to the practice of journalism, and we all need to think through them. But even where we are retaining civil defamation, I think we need to be able to realistically think through what level of damages can be awarded. When one person gets awards of 10 million, 20 million from one media house, is that realistic? And can we really say that damages can be calculated and you are worth 10 million, 6 shillings, or 100 million? Isn't it just a relief that ought to be modest so that it doesn't cripple media houses purely for a professional mistake? Because sometimes media houses, like all human beings, would make a professional mistake. And when they do so, we need to give them an opportunity to apologize, to correct the situation, other than totally criminalizing the profession.
All right. Thank you so much, Henry Maina. He's the Executive Director of Article 19, talking to us about that libel case ruling. Now, like he mentioned, media and bloggers now can heave a sigh of relief after the High Court ruled that no one can be charged with a criminal offense for posting offending messages on social media. That was yesterday. So we want to